So this is Diesel We the People News. Alright, turn the AC off and be a little easier to hear. Alright, this video is without prejudice and or without recourse. Alright, I'm reserving all my rights. I'm not an attorney. Anything I say or do is just my opinion only. Why? Because I'm not an attorney. I cannot give legal advice. Alright? That's why, people. Anyway, I'd never just look straight forward. I always be able to look around me to be able to protect myself by any means necessary. And once again, this is Chris. Article 5. And it's going to be the quick version. You know, try to keep everything in a short term basis. Just a simple fact. You know, some people is retaining it just too long. Alright? So let's check this out on the Article 5.
The history and the foundation upon which our Constitution is built. And when I started connecting these dots and seeing how obvious all of this is, the axiomatic truths and the time-tested principles upon which our Constitution is based, and the ramifications of setting those aside are not unforeseen consequences. They're actually foretold warnings. And I thought, you know, we need to put this in writing in a way that other people can understand this as well.
Are you in favor of an Article 5 convention?
A lot of people ask that question, and it's a very interesting question because I think it's oversimplified today. There is no yes or no answer to that question. And again, when I teach, and I mean to throw your question back at you, but when I teach you ask me, are you in favor of it? I don't teach my opinions. I don't think my opinions are necessarily relevant in the history and application of the Constitution. What I'm more concerned about is how an Article 5 convention is intended to operate. How did the designers of the contract envision this term in the contract to operate? And how will that operate in light of today's vision, errant vision at most, of how the Constitution is supposed to operate? And so the Sovereign Duty book has a whole chapter on that. I also did a week-long series on my radio show, the Chris Ann Hall the Chris Ann Hall radio show. I also have a television show where I highlighted that as well, where we talk about the Article 5 Convention, and I've written several articles on my website as well.
Well, from Sovereign Duty, you write, our framers anticipated the need to amend the Constitution as our awareness of liberty expanded and perhaps our need for government diminished. Listen to Thomas Jefferson's view.
Listen to that. For need of the federal government.
On amending the Constitution, it appears clear that he felt it was needed, but not to be taken lightly. And this is a quote from Thomas Jefferson. I am certainly not an advocate for frequent and untried changes in laws and Constitution. I think moderate imperfections had better be borne with, because when once known, we accommodate ourselves to them and find practical means of correcting their ill effects. But I know also that laws and institutions must go hand in hand with the progress of the human mind.
Absolutely. And the quote actually continues to make an analogy that to force a man to wear the same coat as he wore as a child would be the same as forcing a society to wear the same constitution it wore at its inception. And
that's not living, breathing, necessarily?
No, it is not. Because there is a contractual manner and a specific term under which the modification is to take place. It's not based on a whim. It's not based on modern trends. It's not based on who's ever in political power. You know, is it this party in power at this time, this party in power at this time, this ideology taking control, you know, that kind of thing. Article 5 says, this is how we do this, and this is the only way it can be done. You cannot modify the Constitution's terms by interpretation. The Constitution doesn't need to be interpreted. It's not written in Chinese. It needs application as a contract would be applied. And so Article 5 lays out those terms. And if we're going to have a convention in this modern day, James Madison was concerned about a future convention because he actually says that the only reason we're able to have this convention work today is because we've just come from a bloody revolution, and the horrors that we've seen are keeping the delegates' minds focused on liberty and keeping them from diverting to personal gain, political gain, avarice, and greed. He says, but I'm concerned about a convention in the future. Without such motivation, how would we keep those delegates on focus? And how would we keep those delegates from being the people who made the problem being tasked with correcting the problem? So when answering the question, should we have an Article 5 convention? The answer must be based on the application of Article 5 as it's intended. Why are we going to do this? What's our purpose? Are we going to have a convention so that we can expand the liberty of the people and limit the government even more? Because that was why. When you study the chief reasons for the incorporation of Article 5.
Listen to that part. To expand liberty. Not to take liberty, people. To expand it. Kind of push away the federal government away from you. Not for the federal government to gain control and power over you or the state. That's what the Fifth Circuit.
And you know the history. Every single time that our founders, before they became Americans, they were British. And they were in a kingdom. So every time they wanted to limit government and expand liberty, they had to pick up the sword and fight a king. They gave us Article 5 so that we could expand the liberty of the people and limit the government without picking up a Civil War sword. And so what we have to understand is the purpose of Article 5 is for an enlightened people who need less government, not a mechanism to control an out-of-control government.
KrisAnne Hall is our guest, and before we go any further, let's take some calls and hear your voices. Let's begin with Joan in Newport News, Virginia. Joan, you're on Book TV. Good afternoon.
Good afternoon. Excuse me, this is my favorite show that you have, and it's an honor to talk to your author there. And I wanted to ask her to please clarify the difference with the Supreme Court. For instance, Obamacare, immigration. There's so many of us just see common sense. In the books that I've read about the Constitution, they're not supposed to make the law. They're supposed to interpret the law. So you're very smart, so please tell me the difference between them not interpreting the Constitution and making the law themselves. And thank you for your time, and I'm enjoying you very much.
Thank you very much. That is a great question. When we're talking about the role of the federal government and the acts that they create, there are certain lines of questioning that must be answered. First, is the authority delegated to the federal government to exercise that power? And then second, are they exercising that power within the limitations of their delegated authority? With healthcare, there is no authorization, no delegation of authority to the federal government to exercise authority over healthcare. That is a power that is to be reserved to the states. James Madison, who has obtained the nickname the Father of the Constitution, who is also the fourth president of our United States, wrote a document that we call Federalist 45, and he explains the delegation of power and the separation of power between the states and the federal government. He said the powers delegated by the proposed Constitution to the federal government are few and defined. Those that remain in the states are numerous and indefinite. He says the powers delegated to the federal government will be exercised principally on external objects, foreign affairs, and he names them: war, peace, negotiation, and foreign commerce. He continues and says the powers that are reserved to the states will include all of the powers: the lives, the liberties, the properties of the people, the internal order, improvement, and prosperity of the state. So what we need to understand is if it's not been delegated to the federal government, it has been reserved to the states. Healthcare is the lives of the people, the internal order and operation of the state, the property of the people, which means it is very distinctly a power that is reserved to the states. The Supreme Court does not have a delegated authority to expand what has the power that has been delegated to the federal government. They themselves are limited by the terms of the Constitution because the Supreme Court is a product of the Constitution itself. And our modern Supreme Court has jumped outside of its constitutional foundings. It has created in and of itself a power to determine the power of the federal government. And you know what's interesting is that our founders actually anticipated a court system to do that and made comments on why that's not appropriate. And so healthcare is not a power that has been delegated to the federal government. Therefore, it is not a power that the Supreme Court can grant or sanction for the federal government either. We have 3 branches within the federal government, 3 parts.
Alrighty. I thought I'd let it go on a little bit longer to really just see how much the Supreme Court is over broaden the federal government's authority, qualified immunity, making up doctrines that they have no authority. The Supreme Courts and federal courts went rapid, and we the people have not demanded our Congress to start doing impeachments, because we have been misled and lied to that they actually have a lifetime appointment when they do, if they operate in good faith. They know beyond a shadow of doubt they did not have authority of this, and who all voted on this should have been impeached. And the Senate should have kicked them out, the President to find a new one, the Senate to bring in a new one. If we actually start holding the Supreme Court and the federal courts accountable of having their jobs, our rights would be stored. These will be the people news, so there you go.